It depends, I suppose, on the particular statute and the nature of the history at issue and the question.
But don't you want to just go take a peek? You look at the language and you say, well, this is as clear as thunder on a summer night. But maybe I'll just take a peek at the legislative history to make sure that I'm not out in left field. And the Supreme Court condemns that, does it not?
Welcome back to the channel. Today, we're diving into a fascinating exchange between Senator John Kennedy and a judicial nominee that gets right to the heart of how America interprets its laws. At the center of this debate, should judges rely only on the text of a statute, or should they also consider the legislative history behind it? This conversation goes far beyond courtroom technicalities. It shapes how justice is delivered across the country.
Thank you, Mr. Chairman. Counselor, as you know, it's hard to pass a bill in the United States Senate. Our founders intended that to be the case, and consequently, if a bill does pass, it's gone through a long, arduous process. A lot of reports issued, a lot of debate, and all of it's written down. Why has it become common practice, and do you support it, of ignoring that rich legislative history when you interpret a statute?
Well, Senator, I think the first rule of statutory interpretation is that the text is what's paramount. And that's because the text is what actually proceeded through bicameralism and presentment, which are really just the fancy.
Of course, it's paramount, but why can't the text be supplemented by looking at the history?
I think the legislative history can sometimes provide a tool to help interpret the text, and it's often in parties' briefs, and I would, of course, consider it that way. But it's just important to keep in mind its subordinated role in that interpretation, because the intention of any particular legislator does not have the force of law. Instead, the text does. So the legislative history and the intentions of specific legislators should never take primacy over the text or refute the text.
But it doesn't have to, does it, Counselor? It just gives you context.
I agree with that.
When you interpret a statute or write a brief and you think that the language is plain, aren't you tempted to go look at the history just to make sure that your interpretation is correct?
It depends, I suppose, on the particular statute and the nature of the history at issue and the question.
But don't you want to just go take a peek? You look at the language and you say, well, this is as clear as thunder on a summer night. But maybe I'll just take a peek at the legislative history to make sure that I'm not out in left field. And the Supreme Court condemns that, does it not?
The Supreme Court does not uniformly condemn that, and there are certainly cases where, legislative history or statutory history has provided a tool.
Sure they do. I mean, originalism, and I'm not saying they're wrong. Please don't misunderstand me. I'm just trying to understand your perspective. Originalism and textualism is accepted even by the left of center justices. And I've read opinion after opinion, lower courts as well, where they say, well, legislative history, we can't rely on it.
Legislative history cannot be relied upon to trump the language of a statute. And so when the language of a statute really is that clear, Senator, there's not that much, and it bears directly on the question before the court.
Well, let me ask you something. Does the Supreme Court sanction looking to the Federalist Papers and interpreting the Constitution?
Yes.
Why isn't that legislative history?
The process for ratifying the Constitution is, of course, different than the bicameralism and presentment process that applies to statutory text. The Constitution was, of course, publicly ratified.
No, it's not.
Well,
you look at the plain language, don't you?
Yes. But in looking at the plain language, the question we ask is, what was the original public meaning of that language? And in the case of the Constitution, the original public meaning is elucidated by the debates surrounding its ratification. And those debates are really captured in the Federalist Papers, the Anti-Federalist Papers, the ratification debates, the notes from the Constitutional Convention, documents like that. So those documents can bear directly on the constitutional text in a way that is more legitimate necessarily than the, statement of an individual legislator would be vis-a-vis a statute.
Well, then when we interpret the United States Constitution, and I agree with you, that's the case. I'm just asking you, whether you think it ought to be the case. Then when we interpret the United States Constitution, why do we let lawyers do it? Why don't we just hire history professors?
The history that judges are looking to in interpreting the Constitution and other statutes is primarily legal history. It's not something like, a biography of George Washington. It's instead things like statutes or, debates about statutes, the Federalist Papers. And certainly, I think law schools could do a better job and should do a better job, teaching students how to read that legal history. But it is fundamentally legal history. And then the task the judges have in reading that legal history is to draw analogies between that legal history and our modern times. And that analogical reasoning is, I think, a fundamentally lawyerly task the judges are particularly skilled at.
Thank you, Mr. Chairman.
Senator Kennedy starts with a sharp observation. Passing a bill in the United States Senate isn't easy. Our founders made sure of that. By the time a law gets to the president's desk, it's been through countless debates, amendments, and compromises. Kennedy's question is simple but powerful. If all that history exists, why is it so often ignored by judges? The nominee's response? The text itself is supreme. Once signed into law, the actual words, not the speeches, not the reports, carry the binding force. Legislative history, at best, plays a supporting role. Kennedy pushes further. Why not use the history as a check, just to make sure judges are interpreting the statute correctly? After all, context matters. The nominee agrees that history can sometimes help, but warns against letting it override clear text. According to modern judicial philosophy, especially textualism and originalism, relying too heavily on legislative history risks giving individual lawmakers' opinions the weight of law. Before we continue, take a moment and click that subscribe button. This channel breaks down key hearings, political debates, and legal battles you need to understand. Don't miss out. The conversation then shifts. Kennedy points out a seeming contradiction. Courts regularly consult the Federalist Papers, the Anti-Federalist Papers, and ratification debates when interpreting the Constitution. Isn't that legislative history, too? The nominee explains the distinction. The Constitution was ratified through public debate, so those historical records are tied directly to its meaning. Unlike congressional floor speeches, which reflect only individual lawmakers' views, constitutional debates reveal the original public meaning of a text. Kennedy delivers another pointed question. If interpretation is so dependent on history, why not let historians interpret the Constitution instead of lawyers? The nominee draws a critical line. Judges aren't studying history for trivia, they're engaging in legal history. That means drawing analogies between past legal debates and today's issues. This requires not just historical knowledge, but also legal reasoning, something judges and lawyers are trained to do. This exchange reveals a deep divide in how America interprets its laws. Is the text alone enough? Or should the intent behind it guide judges as well? Senator Kennedy's probing questions highlight the tension between theory and practice, and the nominee's answers underline just how carefully the courts tread when balancing law with history. What do you think? Should legislative history play a bigger role? Or is sticking to the text the safest way to protect the rule of law? Share your thoughts in the comments below. And if you enjoyed this breakdown, hit like, subscribe, and turn on notifications so you never miss an analysis of the debates shaping America's future.